Hi, it's John with Vision Advisors. Welcome to another Insight with Vision. It's Q4 2020, and I want to give you a quick compliance alert and update because of some changes going on in the industry. We've touched on this a couple of times, but I want to give you an update of where we are and help you understand some best practices in a best interest world. You know, your role as a licensed financial professional is pretty straightforward. Number one, you're to conduct yourself in a professional manner. Make sure that you are adhering to all state-specific guidelines as well as any federally mandated responsibilities that you may have as a licensed financial professional. It's also too important to remember that you are licensed to represent the insurance companies that you are contracted with. So you must make sure that you are following all carrier-specific guidelines. Very important in this new regulatory world in which we live that you know your customer, that you're taking time to do the appropriate fact-finding and investigation and understanding their needs and concerns and digging a little deeper to make sure that the recommendations that you're giving are going to, again, be in your client's best interest. This has become a major point in state after state as we've seen regulations enhance, and some of the recent updates in the regulatory world that we'll touch on in just a moment are really, again, bringing this to the forefront. It's also important that you know what you're selling, that you take the time to read the sales guides, to read the brochures, to understand how the products that you are presenting works. You know, gone are the days of flying by the seat of your pants and thinking you can bluff your way through a conversation. The reviews taking place on the back end at the carrier level are such that if you don't know what you're selling and you're not giving adequate disclosure to the customer, at some point that's going to come back and bite you. It's also important that you know how to complete an application. We're seeing a significant number of increases in the number of not in good order applications arriving in our office, or for those of you that are sending them direct to the carrier, we're seeing a significant number of not in good order cases, meaning that you are failing to complete the application correctly or there's material omissions in the process. It's also important to know how to submit new business in good order, especially as more and more carriers are transitioning to an electronic application process. Now, a number of carriers, as I've shared previously, are adopting the Reg BI standards and the new NAIC annuity sales law requirements into their practice. So what's changing at the carrier level? Remember, the new regulation BI passed by the SEC will impact anyone with a Series 6, a Series 7, a Series 65, or a Series 66. And it now imposes additional obligations on you in terms of disclosure and things that you must do in the sales process. Important that you get with the broker-dealer that you're contracted with or the investment advisory firm that you are working with to understand these rules. Now, if you have your own BD or your own RIA, you need to make sure you are educating yourself on these additional responsibilities, again, because you are going to be held personally liable to make sure that those things get done in your practice if you're acting as the principal of your agency. And remember, the NAIC annuity sales law, which is bringing many of these best interest standards to bear in the marketplace, that rule is now being broadly adopted across multiple states. And we're going to see a DOL revised rule that is going to be harmonizing between Reg BI and the NAIC annuity sales law coming to bear probably by the end of the year. As a result of that, carriers are changing their suitability, their underwriting guidelines, and how they're going to be processing information and new business, as well as implementing some post-issue quality control reviews to make sure that they are doing their best to address complying with these new rules. Also important to remember that depending on the outcome of the 2020 presidential election, more tightening of regulations could be forthcoming. One party in particular has said that if they do take control, they are going to move to go to an even tighter standard of conduct for those operating in the financial services community. So what are your new responsibilities as a licensed financial professional? Going forward, if you're not already doing so, it's going to be important that you are completing a fact finder on every client that you meet with. And at every regular review, you are updating that fact finder so that you've got a good understanding of your client's financial situation, their wants, their needs, their concerns, their goals and objectives, and you're regularly reviewing that as you interact with your client on a regular basis. It's also going to be important that you create and maintain a client file. Under the new rules, the Reg BI and the NAIC rules, and likely the DOL rule when it's rolled out, is going to require that you not only maintain a client file, but at the request of a carrier, immediately make that file available as additional documentation to support your recommendation for a product that you are promoting that the client purchase or exchange or replace a product. Very important also that you document every client interaction. Every phone call, every face-to-face meeting, everything you do with a client needs to be documented. One of the most famous statements that I've heard, and I think it's a very powerful statement, if you don't document the conversation, it didn't happen. And the last thing that you want to occur is in the event there is a complaint filed, or maybe there's a misunderstanding with a client and litigation results as a result of that. They're going to have one interpretation of the results. You're going to have a second interpretation. Whoever has the best documentation has the best chance of coming out the successful winner in any complaint that may be appeared. Another new responsibility is going to be solution-based selling. Gone are the days of having the pet product in your pocket and you're selling one or two products and that's all you know. As a result of completing the fact finder and understanding the needs of the client, identifying their wants, their needs, their concerns, and selling to those solutions and evidencing how the products that you're selling meet those needs is going to be an integral part of selling going forward. Many carriers are now asking in their new revised suitability forms for you to provide a written explanation of your recommendation, especially true if there's any type of replacement that's going to be involved. There are, and we've seen a number of carriers continuing to move in this area of having additional disclosure requirements that are going to have to be completed as part of the new business application process. So you need to become familiar with those and making sure that you're properly completing those. Strict adherence to HIPAA guidelines is another big security issue. Making sure that you are safeguarding your client's non-public personal information, especially as it relates to their health, their finances, and other issues that may not be public knowledge, is going to be very, very important going forward. Now, on the carrier end, there is going to be enhanced carrier suitability, and we're already starting to see enhanced scrutiny taking place. We've already talked about additional disclosure requirements that are going to be coming, and many carriers have already added to their app packs. We're going to see replacements be much more closely examined and additional questions asked as to why this replacement is in the best interest of the client. That's where your fact finder and your additional documentation is going to come in handy to be able to validate and to evidence the reason this replacement is going to benefit the client. Carriers are also going to be looking at the product mix that you are placing with them. And if they see you continually writing only one product or maybe one or two products for every client that you're writing, they may be coming back to you and asking for additional documentation to understand why. Again, because solution-based selling is going to become the new normal. Requests for additional documentation is going to be coming more frequently. Remember, the new rules require that you develop and maintain a client file that includes a fact finder and includes documentation. The carrier reserves the right to request any and all of that information as a part of the underwriting process, or in the event there's a consumer complaint filed, they reserve the right to request that information to also validate that information as well. Now, another thing that we're seeing, and it's already happening, is carriers doing post-suitability and quality control reviews directly with customers. They are making outbound calls to clients that have recently received a policy, asking specific questions about the sales process itself, whether or not you disclose specific information, whether or not you refer to specific things in a proposal, making sure that you're giving a full and adequate representation of the product its benefits, its features, its limitations, surrender penalties, surrender periods, things of that nature. That's part of that process as well. And the other thing that we're seeing is carriers are also doing periodic rescreening of producers. If they're identifying issues where a producer is a financial train wreck, they're not paying their taxes, they're behind, they've got garnishments, or they've got other issues going on financially, that may give an indication to a carrier that the type of business you're recommending may not necessarily be in the best interest of the client, but maybe to help you get out of the financial jam that you placed yourself in. So understanding that you functioning as a financial professional and managing your own financial affairs, just as you're asking your client to do, is going to be very, very important going forward. Now, what's coming? What do we see? If we were to rub the crystal ball, what do we think is coming down the road? Here's a few things we think. We believe, and we're confident because of the trends that we're seeing and what we're hearing from carriers, that there's going to be an expanded use of electronic applications going forward. Another area that we're excited about is a number of carriers are working on smartphone applications where you're going to be able to not have to worry about logging into a portal, but you will be able in the future to use a smartphone app from the carrier to do electronic applications and electronically submit business directly to the carrier right off a tablet or your smartphone. Again, technology coming to help make things simpler, easier, but also to eliminate the not in good order problems that many carriers are facing today, because the EAP system for the most part will not let you move forward until that application is completely filled out. Another area we are excited about is the use of artificial intelligence and other technologies that are going to be incorporated into the underwriting process that will significantly speed up the underwriting time. Less reliance on fluids that we've typically seen in old school types of underwriting, and much more reliance on big technology and AI to be able to fill that gap and get us a better underwriting solution much more efficiently, much more effectively, and faster. We also believe you're going to see some continued carrier consolidation. At the same time, I think you will see new carriers coming to the market, but innovation seems to be on the forefront. The insurance industry is looking to catch up in the area of technological advances to where some of the others, the banking industry, the investment industry, have already gone. And the insurance industry is going to be making great strides to bring new innovation and implement more technology to make our jobs easier and more efficient and more effective. But we've got to be willing to embrace and learn those technologies as they come to the table. And again, as we've already said, depending on the election results, more regulation could be forthcoming depending on which party is in charge of the White House. Now, let me also mention some recent compliance issues that we've seen at the carrier level that have been reported to us in some calls where that has resulted in carriers either dismissing a producer or having to put a producer under heightened supervision. So these are some areas I just want to bring to your attention to make sure that you're not engaging in these types of activities. Recently, one where a producer was found that he was having product training done by staff members in the office and not doing that training himself or herself. It is now required when you do product training that you attest to that, that your AML training and other mandatory training, you have to attest and certify under penalty of perjury that you are completing this training. Hey, you are a financial professional, and it is important that you are continually educating yourself and learning and understanding the products and services and solutions you're going to be bringing to bear. This is part of your responsibility. You need to make sure you're doing that. Another issue that we've seen several carriers raise and elevate to the status of asking additional questions and going to clients and asking additional questions is where a producer a few years back sold an income solution to a client stating that they needed guaranteed income as part of their retirement plan. And now just a few years later, that is being scrapped and they're being offered an accumulation solution without a plausible explanation as to why the income is no longer needed. This is a significant issue that carriers are looking at, and you need to be aware that that's a compliance concern that carriers are watching for. Another area that we're seeing as a result of these post-issue reviews, Carriers are finding out that there are producers that are not adequately explaining the product features, the product benefits, not taking time to also explain the limitations, waiting periods, surrender penalties, and what the actual costs are in the event a client decides to walk away from a product with a surrender penalty early rather than waiting until it's completely gone from the product. There's also been situations where in these post reviews, carriers have found that there are some producers mailing blank applications to a client and asking them to complete and return that to the producer. It is your job as a financial professional to ask these questions of your client. By the same token, we've also seen a very similar scenario reported from carriers where they're learning that a producer would meet with a client, ask them to sign a blank application, and then the producer would go back to their office and complete that application without getting all of that information from the client or simply copying it from an application on file from months or years before. It is your responsibility as a financial professional to ask the questions on the application, to complete the application fully and completely. Because at the bottom of that application, the client is attesting to the accuracy of the information on that application, as are you as a financial professional. That becomes part of the insurance contract. And if you're making an attestation to something that is not true, that could be construed as perjury or misinformation, or it could be construed as a fraudulent application. That's where this could go. So we need to be cognizant of that and making sure that we're doing a good job doing what we need to do. And then one recently where we saw a carrier terminated a producer. The producer actually gave a prospective client his login credentials to initiate an e-application because the producer didn't want to take the time to learn how to do it himself. As a result of that, that producer exposed every one of his clients that were in that portal and their information was there to this prospective customer. That was a HIPAA violation that resulted in that producer's immediate termination. So these are some issues that we've seen arise as a result of the enhanced scrutiny and post-review things that carriers are doing. So what's our takeaway from this at the end of the day? And I think it's pretty simple. You're a financial professional. You are licensed to do a job that you need to do. You don't need to relegate the job of completing an application to someone in your office or to your client. It's your job to ask the questions. It's your job to be the consummate professional, to take the time to invest in yourself, to learn and understand and be able to articulate the products that you are selling, the solutions that you are recommending, and at the end of the day, gathering the facts and information necessary to make sure that you are doing what is in the best interest of your client. That's good for the client, it's good for you, and it's good for our industry when that takes place. So at the end of the day, we want you to know that we're here to help you help your clients. As you're trying to navigate this new normal, or I hate to call it a new normal, but it's the reality in which we live today. And as we are seeing these enhanced suitability requirements, these enhanced disclosure requirements, and additional obligations placed on you as a financial professional, we're here to help. If you don't have a fact finder, we've developed some fact finder templates that you can use and modify to create a fact finder that works for you to gather the information that you need to understand your client's wants, needs, and concerns, and to gather the facts needed to make a recommendation that's in the client's best interest. After you gather that information, we're happy to review that fact finder with you and to help you in that review process to identify the appropriate solutions to meet your client's wants and needs, and to give you the rationale behind our recommendation, again, so that you can document that information and have that information available. We're here to give you the tools and resources to continue to educate yourself so that you can become better at who you are. Because when you become better at who you are, you become better at what you do. And of course, we're going to continue to bring you innovative marketing solutions, the opportunities to get in front of qualified prospects, done for you marketing opportunities, great carrier products and solutions, and the coaching and training that you need to continue to grow yourself and to grow your practice. At Vision Advisors, please understand that we have a vision for your financial future. We encourage you to embrace these new changes that are taking place in our industry as a positive. It's going to continue to weed out the few bad apples that are still in the industry, so the vast majority of us that are doing things right can continue to do so and make sure that we are taking care of our clients the way that they need to be taken care of. If you've got questions or concerns, or you're working on a case you've got some questions on and that we can help, give us a call here at Vision Advisors. Our number is 1-800-505-8489. Speak to one of our business consultants if you've got a business consulting question. Ask to speak to somebody on the marketing team if you've got a marketing questions. Ask for somebody in the compliance department if you've got a compliance question, a new business question. We're here to help you see success and to see more success as you move forward. I'm John Terry with Vision Advisors. Thanks for joining us, and have a great day.